Here we are live once again. Thank you all for joining me today. I am incredibly excited about today's show because it demonstrates really the historical debate that has been going on in this country since its inception. And we are often told the reality that isn't really reality. We're told the story written by the victors, but today we're going to show you exactly how we got here to where we are and what we're talking about exactly, because today's topic is about reporting foreign retirement pension plans on what's known as IRS Forms 3520A and 3520. The issue is that if you go and try to find whether or not these things are actually reportable on a tax return, you can't find anything that says whether or not these are reportable. You might find exceptions to things that would imply that some things are reportable, but there is a complete lack of clarity by the IRS on what is actually reportable. And in its wake, the tax industry, people like me, and others have filled in the blanks with our advice on how to do things. And really where we want to start off today is let's talk about the penalties. Let's talk about the penalties that the IRS imposes if you don't file this form for a foreign retirement plan, your life savings, as it were, that if you don't report it. And I'm going to pull up the screen here. I'm going to share the screen that we have here. We're going to go to 26 USC 6677. You know, one of the comments that John made, and now I'm going to adopt this philosophy as my own, is that the United States government is certain penalties for uncertain conduct. That is exactly what we have here, because you don't know the thing that will get you a penalty. But this is the thing I want to just show you here right now, is like, this is the section that is the penalties, right? You can be imposed a 35% penalty for not reporting your foreign retirement plan, maybe, under 3520A, 3520. 35% penalty can be imposed for each time, by the way, for each time. So you can imagine just in 3 years, your entire foreign retirement plan could go away, right? Could go away through 3 penalties the IRS could assess fairly easily. And I want to introduce our guest today, our long-term guest, John Richardson. John has created the slides along with Keith Redmond, the Advocate 2 in the Consulate to Americans Abroad. Good morning to both of you.
Good morning.
So Keith, tell me a little bit. You are our resident layperson, and you are dealing with people who try. You know, the word is really try to be in compliance with the IRS. But tell me about, specific questions you're getting about foreign retirement plans people have around the world, and some of the anxiety and terrible things that are happening to people. You know firsthand. So
I mean, a segment of the people I help try to be in compliance or need to be in compliance, and then there's other people who don't need to be in compliance and just stay away. But for those who try or need to be in compliance, it's very confusing for them because there's no guidance. And they will go to, let's say, tax professional A, who will say, this is how it needs to be done. And then they'll go to tax professional B, and they'll say something that's completely different. And then they'll go to tax professional C, who will even give a third way of doing it. And for them, it's extremely confusing, number one. And number two, it gets to a point where it's like, even though I may have to comply, it's just not worth the aggravation. So I'm not going to do it. That's what I'm finding.
And I mean, could you imagine someone, because this is where if you file, if you raise your hand and just tell the IRS, hey, look, I want to be in compliance. Well, okay, now you have to do this expensive reporting year after year, or you don't file it. And the problem with this, and that we oftentimes, I'll say, well, actually, you don't need to file this, but I don't have any that rock solid, thing I can point to. It's rather by inference, I have to say you don't have to file it. And the risk for not filing here is, again, the 35% penalty. And that right there, I mean, if someone's holding your gun for your head, hey, are you sure? Are you sure that you don't need to file this? Because the risk of being wrong or losing everything.
Well, so, exactly. Unless you just stay away entirely, and some people can do that, but not everybody can.
That's right.
So it's a major risk. And gentlemen, correct me if I'm wrong on this observation, but doesn't this also really drive home the fact that U.S. citizenship needs to be severed from tax residency? Otherwise, we wouldn't have to go through this whole mishigas and mental gymnastics about foreign
Right.
trusts. Am I correct in that?
If that happened, well, I mean, it wouldn't. Essentially, it would alleviate most of the problems because, if you are a resident in the U.S., the chances of you having a foreign, retirement plan that you're actively contributing to, might go away. But actually, you know what? It actually doesn't.
It does happen.
It does. Yeah, no, actually, it wouldn't totally relieve it because we often do have clients who do. I have clients, living in the U.S. right now who have Australian superannuation funds. So RBG actually wouldn't completely solve the problem. It actually would.
No, but for Americans overseas.
For Americans overseas, it certainly would. But really, what would really, I think, assist the most is if we had a legal tax system would actually help a lot. If we actually had a, I mean, the Constitution itself has some problems, but even under under its promises, if the tax code was constitutional, we wouldn't be here. We simply wouldn't be here. But the tax code is what it is. I want to now thank you very much for Keith. So we're gonna go in here. This is what we want to go today is give you the authority of what the law currently is right now and explain to you why there's so much confusion, but really show you the basis for why maybe filing a 3520A, 3520 for your foreign retirement might not be required at all. Really might not be required at all. And joining us is the great John Richardson today. John, thank you. Good morning. And John created some wonderful slides that we're going to hop into. John, you want to get into the slides that or is there part of 6677 you want to go over a little bit more?
Well, so this is absolutely over the top. Okay, it's one of the most egregious offenses against American citizens and residents of other countries that I think I've ever seen. Okay, because when we look at this whole problem, we have a situation where this section of the Internal Revenue Code, again, imposes a very definite penalty of up to 35% of the value of these things. Okay, up to 35% of the value for a violation of Internal Revenue Code 6048, which is a section that deals with reporting requirements of foreign trusts without any definition of what a trust is in the Internal Revenue Code.
There you go, right?
Okay, yeah.
Well, John, I think that's a great thing, and I'll just repeat it again there, that we have this certain penalty. Hey, look, if you don't report this foreign trust, we can impose a penalty of 35%. By the way, we're not really going to define what a foreign trust is.
Yeah, but actually, Anthony, it's actually even worse, and this is part of the problem. Okay, the language of the statute here says the person required shall pay a penalty. Shall. In other words, this is not, something that the IRS has any discretion whether to assess or not. This is Congress.
Wow.
Shall pay a penalty. Okay. Now, the only way out of it is reasonable cause. And if you go down to D, reasonable cause exception, I'd like to point out to you again something that is extraordinary about this section. And we saw this in 6038, I think, in our last podcast. No penalty shall be imposed. So we start off with a mandatory penalty, and then it says no penalty should be imposed, which should be due to reasonable cause and not due to willful neglect. Now, those are two possibly separate things, but anyway. But what I want to point out here is this extraordinary add-on, the fact that a foreign jurisdiction would impose a civil or criminal penalty on the taxpayer or anybody for disclosing the required information is not reasonable cause. So once again, we have here, by God, you break the law of the country you live in. You break the law of the country you live in, okay? And you can't tell us, all right, that just because there's a law that says that you can't report this stuff to U.S. Treasury, that's completely irrelevant. I mean, so this is incredible.
I find that incredible.
It's incredible, right?
No,
Well,
you
yeah.
know what it is, okay? It's like, what was in the Third Reich, the person who said the bigger the lie, the more people are likely to believe it. It's sort of, in that tier. In other words, it's so in this case, it's the inverse. It's so outrageous that I think people wouldn't believe it. Now, this comes to you courtesy of the Clintons, okay?
Uh,
Which, during this era of, you know, just unprecedented viciousness against Americans abroad. We have the foreign trust rules, we have the exit tax, we have the Treasury entity classifications. I mean, the most vicious, unprincipled, unprovoked, unprecedented
yeah.
assault on Americans abroad during the Clinton years. Lying dormant, of course, for the Obama administration to pick up on this in 2008. But I don't think that people understand what this stuff really says, okay, and how bad it is. And I would also point out that these 30, now this stuff is expressed in the form 3520, right, where you're supposed to file this stuff. And this goes to a separate processing center in Utah, which, as far as I can see, exists only for the purpose of penalty assessment, right?
Right. And one of the things that's going on right now too is that unfortunately, one great way to be assured of being, one great way to get assessed a 3520 or 3520A penalty is actually to file the form.
Well, that is a bit of a problem, man. Before we get into this, I mean, let's talk about that a little bit. So the backstory here is that we've got Treasury making regulations on a number of things. We're going to restrict the conversation today to the 6048 foreign trust reporting rules, although there's more in it. And so this has started, I think, a reasonable conversation about this. And DA, to its credit, has gotten it looks to me like around 1,400 people to send in comments saying they're Australian super, they're Canadian TFSA, or this or that is not a foreign trust, which misses the point of the hearing, I think. Okay, I mean, the hearing is not about whether something is a foreign trust. The hearing is about the reporting obligations, right? Because Treasury has authority to modify this stuff a little bit. I mean, ultimately, the question here, I mean, if we really get down to brass tacks, is this: should an American citizen living outside the United States who has a non-U.S. pension plan or tax-favored account be required, in addition to reporting that on Form 8938, in addition, they already get the information, have to file separate Form 3520 penalty-laden returns in a context where there's no indication from the statute and there's no indication from the Treasury regulations defining a trust that these things are trusts anyway. And they're not, okay, in my view anyway.
They're not trusts.
They're not. And this whole thing, I mean, how do we get from 1996 a statute that was aimed at resident Americans offshoring money into a Bahamas trust or something? How in the world do we get to penalties being imposed on Americans abroad who are employed outside the United States and have a pension plan outside? Like, how do we do this?
Well, that would be the American system. The answer is the American system is
tax
the
preparers, the tax preparer industry, because they can't understand the rules, because nobody can understand the rules, right? It's not their fault. But because they don't understand the rules, they manage to create an expectation, at least in certain countries, that 3520s are supposed to be, filed. And so what people do is they do a preemptive, well, I guess maybe I should file it. I don't know whether I should, but I guess maybe I should to avoid a penalty. And then by filing it late or filing it in some way or another, what they do is they generate the exact penalty they're trying to avoid. And this has to come to an end now. It has to come to an end now. Treasury, I think, has a moral duty here to actually protect American citizens from the tax preparation industry.
Yeah, I think that's a great point, right? But John, that's the entire design of it. Yeah, because look, the U.S. tax code is a psyop. It's designed to demoralize us and dehumanize us by creating these uncertain uncertain conduct for this certain penalty, it's a way to keep us in line because we don't know the thing that's going to happen that's going to result to the total tragedy. That's the whole way to get people to do things what they want. This confusion is 100% by design. And this sentence right above here is what I'm fixated on. This right here, I'm fixated on right here. No penalty shall be imposed by this section on any failure which is shown to be due to reasonable cause and not due to willful neglect. Now, if you go to law school, one of the things you learn in your torts class is you go over the various states of mind that are required for specific act. Also, criminal law. If you go through the states of minds required for the acts. We start with strict liability, which means, hey, look, if you did the thing, it doesn't matter what your mind is, you're guilty, right? A speeding ticket, that's strict liability, right? Hey, look, your car is going that fast. We don't care what the reason was it's going too fast. We're going to give you the speeding ticket. And as you go up, and as specific intent charges like murder, specific intent, you had to mean to do the thing that you did. Now, and then you have a bunch of things in between. You have negligence and recklessness, right? You have strict liability, negligence, recklessness, willfulness. Those are the states of minds here. Now, this makes absolutely no sense to me, which is due to reasonable cause and not due to willful neglect. Now, this word right here, willful neglect. Well, hold on a second. You're saying willful negligence? Willful is a specific, means you mean to do it. Negligence means like, well, you should have known, but oh well, something happened and you didn't mean to do it, but it happened. And you're combining these two things. Well, which one do you mean? Do you mean willful? Do you mean willfulness or do you mean neglect? Which one is it? Well, we're going to combine these words into an unknowable standard that can mean either one. That right here in the reasonable cause exception is intentionally confusing. And this is what I would also say on the Clintons is that, I have, being an attorney for the years, tax attorney for the years, I have gotten a perspective on this world that very few people, other people have. But I have talked to people all around the world. Some people well-known, some not so well-known. But I can tell you for a fact, the Clintons were incredibly, incredibly vicious people who absolutely broke the law to extract revenge on people that criticized them. And I did talk to an attorney who did, I can't tell you too much about the facts, but there was a massive scandal that the Clintons were involved in, and that he represented a client injured by that scam. And the Clintons unleashed the Department of Justice on this attorney, and he wound up with a $2 million tax evasion charge that was completely invented. And that is the Clintons. And so when we're looking at things like this, understand who signed it into law. Some of the most evil, vicious, vengeful people imaginable. And that's just a fact. And if you don't know that, it's just you weren't exposed to the truth. But if you know the Clintons, they were utterly, utterly disgusting. And they're not the only, and the thing is, they got along great in Washington, though, right? They got along great in Washington. And I think that's one thing to be aware of. And so that's a incredibly nasty, when we have this, right? I mean, when you say that the uncertain conduct, we don't even know what willful neglect is. I don't even explain to me what is willful neglect.
That's looking at only one half of the equation. Okay, the first half is whether you have a foreign trust or not under 6048. I mean, that's the first part of the problem,
right? And
it's very, very clear that. I call these in our presentation, I just call them Americans of Broad Things, AATs, Americans of Broad Things. It's clear that these were never designed for tax evasion. It's clear that they're not about taking capital outside the United States and, offshoring it. I mean, it's very, very clear that the purpose of these laws was in no way ever intended to apply to this situation. Then we ask, well, do we have somehow what I would call statute intention creep? And, you look at the regulations. I mean, I'll be goddamned, okay, if I can find anything in the regulations that would somehow allow any reasonable person to believe that a non-U.S. pension plan or a UK ICE or a Canadian TFSA is a trust within the meaning of this. It's simply not there.
Yeah.
So the question is, Steppenwolf had a great song in their Monster album called From Here to There Eventually, right? And I was kind of thinking about that song as I was putting this together, because I asked myself, how in the world can we possibly go to a statute that was in no way related to this stuff? And all of a sudden, the pensions of Americans abroad
Yes,
are
there
being
you go.
confiscated under this statute. How is this
Yeah.
possible?
I'd like to ask a question, if I may, and it's just a little bit further with Anthony's question to me about the people with whom I deal. And this question is a bit provocative and probably not very kosher. But what happens if you are quote unquote US tax compliant and you do not divulge your foreign pension? And you just move forward. You just don't put it on your US tax declarations. You don't divulge it at all.
U.S. tax compliant. I mean, this is
Well, that's why I said quote unquote.
Yeah, well, and I would say, yeah, Keith,
because I know people who have done that. That's why I'm curious.
Of course they've done it, and most of them don't even. They didn't do it because they didn't think they had to.
Right.
That's true. That's true.
Let's keep the context realistic.
Right.
Well, in their right mind.
Right.
I mean, close your eyes and think about this for a minute. So you got some hardworking schmuck in some country outside the United States, goes to work every day, has a pension in the country, trying to feed his wife and kids.
What a jerk.
Goes to his tax preparer, right? And the taxpayer says, "You don't have any foreign trust, do you?" He says, "Of course not."
Yeah.
Right. Why would you think you have a foreign trust? No plan. Now, we got to get to your slides, John. But before we get to that, this line right here is cracking me up a little bit too, just to understand the complete absurdity of how awful our government is. Okay, because in order to certify your non-willfulness, if you haven't been in compliance with your tax obligations and you're overseas and you made that innocent mistake, or maybe for whatever reasons, you go through the streamlined program, you have to certify under penalty of law that you are in compliance with all the tax laws of the country that you're living in, right? And this is if you're doing the streamlined one. But right here, if the tax code of the other country says you can't share other information, or will give you a penalty, guess what? You put in a situation where, like, well, which law are you going to break? Are you going to break the law of the country that you're in, or the country that's claiming tax jurisdiction over then you're not in? I mean, that's really the complete absurdity of how bad this stuff is. They're putting people in situations where they can't be in compliance. Isn't that amazing? Isn't that amazing?
Look, what's going on here is that citizenship taxation automatically creates dual tax and tax residency. We've talked about this, but also dual criminality, right? In a situation like this, right? Or at least potentially. And, I'm amazed that, it's very clear to me that nobody in the world actually reads these statutes. Because if they did read these statutes, you would see conversations that are approximating the one we're having this morning. This reminds me, this is McCarthyism brought into the Internal Revenue Code.
No, it's beyond McCarthy. McCarthy was right, by the way, I would say. He was right. This is just the United States from its inception. This is exactly the duplicity that the United States government, what George Washington himself would approve of. George Washington himself would say, this is fantastic. We are able to control people effectively, and we're now able to build the U.S. empire. And you know what? We're going to do, we're going to do favors for our buddies, and we're going to punish our enemies, which are basically regular Americans. That is the American system. That's what it's been. That's what it's been from day one of the U.S. Constitution. So let's get on to the slides here. We got to get to these slides. You did a great job on this. So here we go. Can we trust financial and retirement planning that is un-American? Right?
It's un-American. Okay.
It's un-American. It's un-American to invest anywhere in the U.S. And that is what it's about. The American system. Let me just get to this. We'll get to this later. But the American system is designed to say, you know what? What happens outside the U.S., if it's something that happens outside the U.S., we're going to punish it, because everything should be done inside to benefit a few select people on the inside. That's the entire part of it. Tariffs, High tariffs. Why? To protect the industry of Washington's donors and to restrict. And this is the thing that people need to understand. The battle, folks. The battle is, folks, you might have heard this, Adam Smith, and I think you have a quote from that. We'll get to that in a second. Adam Smith was all about free trade and liberty. Okay? The American system is the opposite. The American system is the exact opposite. No, we don't want that idea of liberty. We want one central government that determines the winners and losers of everything. That is the American system. It's supposed to build the American empire. That's the purpose of it. This was George Washington. His predecessor was Henry Clay. Henry Clay was the biggest advocate for the American system, which included big banks, by the way. Andrew Jackson was opposed. He was someone who was directly opposed to Henry Clay. Now, Henry Clay's predecessor or successor was Abraham Lincoln, who was the father of the income tax and the father of citizenship-based taxation. It's no coincidence. This is what it is. This is the American empire. This is the American system, which is, again, adverse to the Adam Smith concept of liberty, directly opposed to it. And I think that's one of the things we got to understand. This is not, again, an old battle. Here we go. Thank you, John. Here it is.
I'm going to give a shout out to CPA Gary Carter. This is out of his submission to Treasury, which is a fantastic submission. But he identified this.
Yeah, we'll get to his tweet there. Yeah, that this is amazing. John, do you want to read it?
Sure. All right. So this is Adam Smith writing in 1776, a year of, I think, some significance.
Maybe.
American history. But in any case, and this ties into our Charles Adams stuff, the tax which each individual is bound to pay ought to be certain and not arbitrary. The time of payment, the manner of payment, the quantity to be paid ought to all be clear and plain to the contributor and to every other person. Where it is otherwise, every person subject to the tax put more or less in the power of the tax gatherer, who can either aggravate the tax upon any obnoxious contributor or extort by terror of such aggravation some present or prerequisite to him.
Wow.
So, that describes what's going on exactly, doesn't it?
That is exactly it, and that's what's been going on. And again, and this is, Washington, D.C. is directly opposed to this.
Adam Smith, if he were American, I'm sure would have renounced. Anyway,
yeah. And here we have, there we go. This is always a nice thing to have hanging over your head.
Well, we all know the sword of Damocles. I'm rephrasing it, the sword of penalties. I think that what you ask yourself, we've just passed July the 4th, and Americans ask, what does it mean to be an American?
What does it mean to be an American?
And I think that, if you look at it from the perspective that we're talking about, what it means to be an American is to try to escape a penalty 24/7.
Yeah. Those penalties are all there to keep us in line. And then hey, look, they get our penalty avoidance is their desired. It is what they want us to do. That's the desired conduct they want to.
Sword of penalties. I like that. You like that, Anthony? The sword of penalties.
The sword of penalties. Ever. Yeah. We don't even know what's hanging over our heads, right? Hey, if that's there, what else is there? We got to wonder, right? So here we go. Some more.
This is from Dickens, by the way. I was, my mind was in other places putting this together. But
we need to do that sometimes.
Exactly. Now we have Dickens, A Tale of Two Cities. Remember how it started?
Yeah.
It was the best of times. It was the worst of times. It was the age of something and the age of something else, right? But anyway, so we rewrite the best of times. It was the age of forms. It was the sword.
Oh, yeah, and I just want to. Do we have a new comment from a new visitor? So we are going to get to this question in a little bit because we have exactly this thing. We'll be answering this question in a little bit. So
actually, there's 3 different answers to that question. By the way, keeping it simple.
All right.
But here, the main point is this. What I find incredible about this whole system is the people that penalizes the most are the people who try the hardest to be in compliance.
It's true.
This is so perverse, right?
It is so perverse, yeah.
And there's this great a comment, and I've got the link in the comment to somebody, up on the regulations, where this guy, in a nutshell, here's what happens, okay? He's got one of these UK tax favored plans, and all of a sudden he reads something. Oh my God, I should have been putting this on a form 3520. So he goes and files a 3520 with the help of his tax preparer, I think. gets a penalty, and the cost was almost a year of his income that he paid for trying to be in compliance.
Right. Yeah. That's what you get. That's what you get. Yeah.
Okay. You can't make this shit up. It's unbelievable.
Yeah. And by the way, and I could just tell you this, the penalty process for this is utterly absurd. It's utterly absurd. What you get in the mail when the IRS assesses a penalty because you filed the form is you just get a notice. There's been a change in your account. What's that? Oh, you've been a penalty increase. What's that? 3528. No explanation. No anything. No person was involved. It was an automatically assessed penalty with no reason why other than, oh yeah, you didn't file this for this. And there's no, they just go, they send the penalty first with little explanation and then whatever, we'll move on. And again, and this is often for the people, now oftentimes we're able to, and this is the thing, we're able to remove these penalties because these are in cases where people filed the form. Again, when filing the form, now the IRS says, oh, you have this form to file. All right, well, let's penalize you for filing it. And they do it constantly. And it takes oftentimes, if you don't use a taxpayer advocate, it'll take you about 3 years to resolve it. And it'll take you about 6 months if you use a taxpayer advocate.
Yeah, but Anthony, just to keep the context here a little bit, I mean, we agree on all this stuff. But when we look at this revenue, this regulation discussion we're having, I think the real issue, and this is supported by our discussion, is that I think the Treasury has an obligation to protect the American people from, the overreach of the statute. I think the Treasury has a moral obligation to step in and protect Americans. Now, they tried that to some extent with Rev Proc 2017. But I mean, understand that the problem here originates from the statute, not so much the IRS. And although I don't think the IRS has been hugely helpful,
No,
I think that presents an opportunity if this is phrased properly. And then I'm, trying to figure out how to phrase this, for this hearing in August, right? But, I really think the issue is if we start from the principle that these things are reported as foreign financial assets in Form 893, I think the real question is,
we have that up here, right? We have that up.
Should they be required, to be reported separately on a Form 3520?
Right, and I think you have that up here. We have that.
Why the duplicative reporting?
Here we go. Right. And here again, right here on the FACA form, like, well, the FACA form, you have foreign. I mean, I would say, yeah, it's a custodial account. Is a custodial account, and is a custodial account tantamount to a trust? That's sort of the leap that we're making here, right?
Anthony, that is not the issue. My view of this is that the way Treasury should deal with this is simply by saying, you know what, it's hard to get into the issue of whether this or that is a trust. But in the interest of certainty, fair tax administration, and low-cost tax administration, we're going to make it clear that regardless of the status of these things, the following things are not required to be filed on a Form 3520, and here they are. 1, anything that's exempted from reporting under Annex 2 of a FATCA IGA. Okay? 2, anything that meets the definition of a tax-favored account in the taxpayer's country of residence. Okay, so in New Zealand Kiwi Saver, Canadian UK ISA. Why? Because it's created under that legislation.
Right.
3rd, anything that's exempt from reporting or anything that's exempt from taxation under a U.S. tax treaty. And then 4, if you haven't knocked everything out at that point, anything that meets the requirements of Rev Proc 2017.
Well, excuse me. Now, if I could just hold on a minute, because I've been asking people what meets because Rev Proc 2020 was relief given, and this is the only time that I have found where a foreign retirement plan comes up with the IRS at all in regards to 3520, 3528 is in Rev Proc 2017. Rev Proc 2017 only applies to retirement accounts that tax advantage foreign retirement accounts that where additional contributions are not allowed. So that means Rev Proc 2017 can't apply to Australian superannuations, can't apply to Kiwi Saver, can't apply to ISAs, can't apply to, and I'm trying to think, and I actually put this question out there on Twitter and on Facebook. Hey, could people help me out? And Keith, maybe I don't know, in France, is there a foreign retirement, a tax advantage retirement account in France in which a person cannot contribute additional funds?
Participation. Yeah, there is.
There is.
Yes, there is. If
Okay.
and it's usually with big companies where they'll have money that's put aside, but you can't contribute on your own. It's just put aside like
Okay.
an extra month's salary. But that's not the standard, if you will.
Okay. So, and I think, and that's one of the vicious things about Rev Proc 2020-17 is many people think it applies to them, and they're using that as a basis to say, oh yeah, I don't need to do it, but it's very incredibly limited. And to me, that the Rev Proc 2020-17 exemption does more harm than good, because it puts an implication that everything else does need to be filed. Right? Because like, okay, we're going to exempt these things, which who knows what they are. I don't run into them. I do not run into them a lot, whatever they are. Rev Proc 2020-17, I don't know if we've ever used, because we don't have the clients that have those things where additional contributions are allowed. And so by creating that, they're like, oh yeah, so it was a backhanded way to say, well, yeah, everything else is reportable, but where's the basis for it? And that's what we're going through today. Where is the basis for claiming that these custodial accounts, which they are, contracts are actually foreign trusts, when there's not a foreign trust? There's no trust document. Where's the trust document? Who's the settler? Who's the trustee? What happens when there's a dispute with the trust? What's the jurisdiction of the trust? None of those things that go into forming a trust document are there, other than someone else is holding your money. That's all it is. Someone else is managing your money for a time. Well, if that's the case, so many transactions that we have all the time, when you're let here, take this money for me and be my agent, that's all of a sudden a trust. Anytime you're giving money to someone else to handle your money for you is automatically a trust. And that's so absurd, that a trust is something you need to specifically intend to make with a trust document that seems to be awfully missing when we're going through this. And so, anyway.
Look, well, let's keep this a little more simple, okay? What the discussion that you and Keith have been having proves beyond a shadow of a doubt is this: that in order to apply, some kind of an exception in Rev Proc 2017, two things are required. The first is you have to understand assuming a trust, right? These things never get into what is a trust, but assuming you have to get into what Rev Proc 2017 is actually saying. And that's not easy to do necessarily. But the harder part of the problem is evidenced really by what Keith said, which really reflected uncertainty about what the characteristics of these non-US financial products are. So to apply this stuff, you need to be able to do two things. Okay, you need to be able to understand what Rev Proc 2017 is saying. And a large number of people can't. But in addition, you have to have a very accurate understanding of the characteristics of the non-US financial product to be able to apply it at all. Because if you don't know, it's not good enough, well, it's tax-free wherever it is. You have to understand a great deal about it. When you combine those two requirements, I think it makes it incredibly difficult to apply these exceptions the way Treasury is presumably intending to do it. And that's why the right way to go about this is, we're not going to get into whether these things are trusts or not. Maybe they are, maybe they aren't. We're not going to get into that. But what we are going to say is that whatever these things may be, you don't have to report them on a Form 3520 or 30.
There we go. Wouldn't that be nice?
That's the right way to do this.
Right. We don't care if they, right. And that's why, and Melvin's got a great comment here. And just, Melvin, I do think actually I know where it comes from. My petition now is this: if that type of financial instrument is not a trust in the U.S., attaching the word foreign cannot turn a non-trust into a foreign trust.
Correct.
Actually, if we do look at, because I was looking at section 402B, some of the retirement sections, and I did see in there that Form 5500 is the tax form that an employer has to file or the plan administrator has to file on behalf of a retirement plan, and that you do find the word trust in there. And so that the U.S. government actually does define a domestic, a retirement plan as a trust. And I think that's really where the problem was created.
Well, that may be the genesis of
and that's probably the genesis of it. And it's just sloppy. And now we're led to this completely absurd result with that. And now, and it wasn't, it's not a necessary thing, because you file the form 5500, not a 706, right? 709. Anyway, well, let's continue.
Yeah, calling something a trust in the Internal Revenue Code does not mean that it's a trust within the meaning of the Treasury regs.
Right.
Okay, and that's true whether this is in a foreign country or the United States. You have to look at the characteristics. No way was this section 6048 intended to apply to the things we're talking about today. No way.
Absolutely right. That's exactly right. That is a very true statement. All right, so we go. All right, we've gone over this. We've gone over the law, the obligation, the penalty. All right, we've done that.
Gone over that.
All right, so let's get on here. And here it is, the penalty bonanza. We've gone over that. And now we've gone over, let's see here,
here's the problem, right? The tax preparers face. And, and although, yeah, I am critical of them without a doubt, but at the same time, I understand the dilemma.
Yeah.
So I'm going to call these Americans abroad things, right? AATs. We can adopt that from here on. So we know they're not instruments of tax evasion, right? Okay.
No, right. Yeah, we know that.
But are they trusts? So you're a tax preparer. And I think this is particularly true if you're dealing with a client who lives in a country that you're not overly familiar with. So you have to understand what a trust is under the Treasury regulations. You have to understand the legal factual of the American abroad thing. In other words, how does it work? And then you have to apply the Treasury rate, and you can't apply it with any certainty. That's the trouble. But we know these things are reportable, whatever they are, in Form 8938 anyway. So once again, just what Treasury should do is say, look, it's reportable on Form 8938, and we're not going to get into whether these are trusts. We're just going to say that these particular things are not reportable on a 3520. That's the way to handle this.
Yeah. It'd be so simple, right?
Yeah. Now here's the dilemma, right? And this is what's caused so many people penalties. Well, I don't know, if it's a trust. I don't know if it's reportable on a 3520. Well, I guess to be sure, maybe I'll put it on a Form 3520.
Yeah.
Well, there's your guy in the UK. It cost him almost a year of salary.
Yeah.
That's the price you pay. I guarantee. Well, I can't guarantee, but I would bet my last dollar. Well, I don't have any dollars either. But what I'm saying is, I doubt very much if the person had not filed the form, a damn thing would have happened. Okay.
True. I have not heard of we do get a lot of people calling us all around the world. I've never heard of an examiner assessing a 3520 penalty when it has not been filed. Only I had I had a great one where it was actually a real foreign trust. The client actually created a real foreign trust in Cook Islands, and this is just a hilarious story because the examiner kept on asking hey, send me the trust return. Send me the trust return. I said, sure. And so I faxed her the 3520A. She said, hey, are you going to send me that trust return? I said, sure. Send it to her. Again, so I sent it to her again. And she goes, what's going on here? Why are you delaying? And then I said, wait a second. Do you know that a foreign trust goes on a Form 3520A? And there was silence. And she did not. She did not know that the 3520A, the foreign trust is reported on a Form 3520. Now, the question is, do you think that stopped her from assessing 3528 penalties? And the answer is no. Now, of course, she didn't understand the form, so she sent it off to a technical specialist who says, oh, yeah, there was information missing on this that made it substantially incomplete. So now the client reported this. Now, he had the help of a fancy firm in Miami that did this. They went ahead and assessed $2 million in penalties that are currently still being contested. So again, the IRS doesn't even know their own rules, but that, just because they don't know what is required doesn't mean they won't assess you a very, very certain penalty. So
Yeah. So Anthony, I think one thing that needs to be added here, okay, there are Americans abroad who do have foreign trusts.
correct. Yeah.
Okay, they're set up for this reason. They clearly are foreign trusts. Okay, and we're not talking about that particular situation.
Right.
Because the law, 640 clearly applies to that situation. What we're talking about are the American abroad things, right? That people just default into because they live in a country, right? But I mean, there's no doubt that a lot of people have been very, very significantly damaged by trying to comply with this stuff in uncertain circumstances. And that, by the way, was the genesis of Rev Proc 2017. And I think that, Treasury should be commended for trying to deal with the problem.
No, I disagree 100% because its relief is only more confusing. It didn't help because you're only confusing that. And I disagree with 2017 is one of the worst Rev Procs.
In their minds, they're trying. And this current thing is an opportunity, to get them to see why, these attempts to generalize, what does trigger a reporting requirement doesn't. It doesn't work because it's not understandable, and there's no need for this stuff. So just stop it. Stop it now, right?
All right, let's see. So now we're going to go through okay. So let's go. So we have some various different ways that some tax professionals are doing this, and they're putting it out there, which I congratulate for them. And you'll see that they don't know themselves, right? KPMG, one of the big four, they're not entirely sure themselves, right? And with good reason.
Exactly.
So if KPMG,
well, again, let's be a little more clear. There are foreign trusts, okay?
Right.
What we're not sure of are, is in relation to the American abroad things, right? That's
right.
the area of confusion.
Right.
Foreign
trusts do exist.
They also say here, I mean, I've given links to, I've laid this stuff out, better on Twitter, right? But, they're very, very clear that there are all kinds of people filing these things who don't have foreign trusts, right? Or who may not, because they're scared of penalties. And this is an absolutely deplorable situation. We haven't talked about the financial cost of preparing a 3520, which is,
what? I do have the tweet up. Let me get this tweet up that you have on. Get this here because this is from KPMG. Some great stats here. So about 50,000 forms 3520 and 17,000 forms 3528 are filed each year. Okay, now.
Making it clear, by the way, the vast majority of Americans abroad do not file 3520s.
That is the point I'm bringing up because again, there's actually real foreign trust there that we're talking about, an actual real. What number of these are people reporting foreign bank accounts? And so I think the thing to understand is there's not a lot really filed now, is there? Right? I mean, that's really not filed when there's 9 million U.S. expats overseas. Keith, is that right? 9 million U.S. expats overseas.
Yes.
And there's, how many of those have some, if you're in Australia and working, you have to have a superannuation. You can't not get around it. So many of these are mandated in the country of which you live. So, I mean,
right, or you're paying automatically into the state retirement system.
Yeah. And so again, the section, the purpose of, here it is right here. They're like, the purpose of this is to limit tax evasion of U.S. tax. Someone has working for a living is not really great for tax evasion, right? You want to do something a little bit more profitable, I would say, right? If you're going to engage in tax evasion. All right, let's get back to some of the other treatments out here. And I do have his.
I've just picked some of the better submissions. So Daniel Price, if you read the submission, has a long history of being involved in compliance issues with the IRS. He, I guess is in private practice now, but I mean, very, very sympathetic to the issue of the American abroad things. Very sympathetic. And
Right.
I would have to think that, a submission from somebody with that degree of experience within the IRS is probably going to be weighty. But, I mean, my God, we've got, people whose, origins are within the IRS talking about how crazy this is, right?
Right. Right. He's got some really, really. And if you, by the way, if you go to John's, if you could get all of this by following John on Twitter at expatriatelaws.com. That's where I'm looking at all these things on his Twitter right here.
Yeah, I mean, what I've done is I've just taken excerpts, screenshots from various parts of the submissions, right? But a lot of Mr. Price's stuff here is fairly technical, but I mean, the general approach and sentiment is fairly clear. Okay, that it's time to rein this tyranny in when it comes to the American abroad things, right? Look at this. To reduce compliance for a middle class, we recommend exempting from reporting all foreign pension retirement plans that are afforded beneficial treatment under income
Yeah.
tax treaties. Good. Provides an example of that.
Yeah.
Etc. I mean, it doesn't go as far as I think it should, but I mean, you have to see, what's the what was that great movie on the basis of sex or something about Ruth Bader Ginsburg? She quotes the constitutional scholar Paul Freund talking about, a difference between the climate and the difference in the weather. Okay. I mean, things like this from Mr. Price, I think could cause a change in the climate as opposed to the weather of the day. And I think that, Americans abroad ought to give a shout out to them.
All right. Well, thank you.
Next here.
All right. American College of Trust.
Who really understand this stuff, okay? I mean, really understand the issue of trust.
All right, let me see where if I have them here. I did have. Let's see. There's Gary Carter. Let me get a.
Same general comments, okay? Same general. A lot of stuff, obviously, because remember that this revenue thing, this proposed reg goes way beyond 6048. But enough of the, generally enough already. Okay, come on, let's stop applying this stuff in areas where it was never intended to apply, right?
Yeah. All right, let's get, and then we have, and I have ABA section.
Okay, now this is by far, I mean, I think they're all great submissions. That's
yeah, this one's pretty good.
This is, I think, by far the best, the ABA. Now, this is the best analysis I've ever seen of why a TFSA is not a trust. By the way, for Canadian listeners,
yes,
I mean, it's long been my position these are not foreign trusts, but here we have, I mean, who believes me, right? But I mean, here we have, the ABA Tax Committee going through roughly the same analysis, but in more detail. And they're saying that, no, these things are not trusts, right? But what's really fascinating is they say what they are. They're talking about these as agency arrangements, and they say what they are and why they're not trusts. But I mean, the point is that this is a very, very, an exceptionally well-written analysis, exceptionally well-written. And by the way, the reason it's so well-written is you'll notice that you see those ITA, that means Income Tax Act of Canada. Remember I said you actually have to read, the legislation. They're actually doing that. Almost unheard of. To read.
Beautifully written. Yeah, this is really well written, I got to say. Hats off to them.
But I mean, I think that for those of you in Canada, send this off to your tax preparer. Okay, because I think that it really does show analytically why TFSAs are not trusts under the Treasury regulations. Okay. And by the way, they actually recommend a blanket exemption for TFSAs.
Right.
Oh.
Just it's because it is, but you're not being clear, right? You're
happening Canadian from reporting under 604 because they're not oh my God, they couldn't. Who could say it better than that, right?
Something they don't. I mean, a lot of this comment.
The both deposit subject to reporting. Okay. When and whether, anyway, it goes on and on, okay, but that's all you need to know. I mean, it's fantastic. All people in Canada need to download the ABA tax session thing and send it to your tax preparer and say, why have I been filing these things for the last however many years?
Yeah.
Next, what do we have next?
We have
Gary.
We jumped ahead already. Thank you, Gary, for that.
3520 and 3528. I made a mistake. superhero, not hero.
There is here, right? Understands Adam Smith, and he gets the debate. That's amazing. Yeah.
Yeah, well, he actually was the person who, managed to generate the discussion that resulted in Rev Proc, or at least one of them anyway. I mean, he really is just gone way out of his way to help on this issue. Hey, Americans abroad.
Okay, hold on. I got their comment up here. Let me get this up here. Okay, here we go. I think this is from it.
Interesting submission. I think the most important thing about it. Did I highlight that, or was that highlighted in their thing?
Well, that was I actually here. Let me just show you where I got that from here. So that was this one here, but
yeah. Well, I mean, ACA is saying, come on. I mean, look, people don't know whether these are trusts or not. At the very least, people need to be given some direction on what are not trusts, right? I mean, it's a good and legalistic analysis, which is what I would expect from, this would be Charles Bruce primarily, right? Their legal counsel.
Yeah, right. And here is, and again, the point that I made before is that, when writing rules for trust, here the focus is being on foreign trusts. It should be recalled that around 2/3 of the countries in the world, to one degree or another, do not recognize common law trusts. Some, like Switzerland, at one time did not, but now, in a fashion, do. I'm actually not sure if that's true. I don't think trusts are still allowed. But again, one of the confusing issues is that if you have Mexican land trust, isn't considered a trust.
Well, what he's saying, okay, is the fact that whether it's called a trust or not called a trust does not determine the issue of whether it's a trust under the regs. That's what he's saying. Okay. And here we go. I mean,
well, right, and this would be helpful. Like, well, tell us they're trust or tell us they're not. How about that? Let us at least know what we should be doing. If you want it to be a trust, let us know. Then we can just, hey, look, end the debate. Hey, it's a trust. You got to file the 3528. Okay. Well, but they won't do that, right?
Pausing there for a minute. I mean, I think that you're walking into the trap a little bit.
All right.
It gets very confusing when you start trying to think about whether these things are trusts or not. One group of people can say yes, another group can say no. Therefore, my suggestion is let's get out of the discussion of whether Americans abroad things, AATs, or trusts or not. Let's just get a blanket exemption from 3520 reporting regardless. That's the way this should plan.
Oh, no, I agree with you. My comment was more just to demonstrate the absurdity.
Oh, yeah.
They won't even say. It's not that they won't even come out with the wrong conclusion. They won't even articulate the wrong conclusion. They just say, oh.
Well, they don't want any conclusion.
They want nothing, right? They want nothing, and they want to, right? They want to continue.
Penalty, definite penalty for indefinite conduct. It fits in perfectly.
Absolutely.
We reserve the right to hit you with a 35% penalty, but we won't tell you what for.
We won't tell you for, because that would limit our ability to torture you, right? If they did that, right? They don't want to do that. We want to make sure we can keep you under your thumb. We have Democrats abroad here, and I'm at their site here, and here's their submission, and they're suspend foreign trust reporting requirements for non-U.S. pension and retirement accounts where the U.S. has no significant tax interest. Well,
I wouldn't have added that. I think that
what does that mean?
What does that mean?
Reporting. The issue is 3520 reporting, whether there's a tax interest or not. Okay, I mean, all Treasury should be asked to do is say, look, let's sidestep this whole issue. Let's just say that these types of things are not reportable on a 3520. That's it. Okay, all the other issues can remain live.
Right, and then I would say, they clarify, okay, which accounts do and don't need to be reported by issuing a list of country-specific account types. And wouldn't that be something if the IRS actually, instead of just having, people, file and say, okay, uncertainty, they had to go through country by country to say, hey, look, we're taxing this. This is what we're claiming it is. This is what we're claiming to do, but they don't, right? And that just, that sort of clarity takes away the power. Clarity takes away power. And they love the confusion because it just creates the entire mess of the potential penalties that could be imposed at at any time. All right, so who else do we have here? Who else? We coming in at the end here. Oh, C.
Yeah, well, here's ours.
Yeah.
Obviously, I agree with that one the most. But I mean, again, the point that in writing this that I tried to make is let's sidestep the confusion. The issue here, there's a moral imperative for taxpayer certainty and stuff like that.
Yeah.
Let's just exempt these things from 3520, regardless of what they are, and move on.
Yeah.
Reminding you that they're reportable on Form 8938 anyway. So what's the big deal? Maybe Treasury responsible. Then how can we assess penalties? Well, okay, all right. Well, the answer is you raise taxes on resident Americans. If you're looking for a loss of penalty revenue, I mean, why not just this came from the Democrats? Why not just impose a tax on Democrats?
There you go. Right. And again, here we have the Treasury has a duty to, but again, I think that's the sales pitch given about our government. But our government is, separate the sales pitch from what our government is, and that's kind of what the difference that we get here. All right, so we're reaching the end here. I'm just going to go through here. Just some comments we could get to here. Melvin, essentially any financial instrument where you have a modicum of control, able to withdraw yourself, make investment decisions, cannot be a trust. I
think that's a defensible position.
Yeah. Right. Again, right. Exactly. Right. Because your limitations on taking things out are usually just on age, but you have control to take it out. So it's essentially an alter ego of yourself that someone is managing at a time. But again, it's a custodial account, not a trust. And I think that's a huge difference. Let's see here. If we got anything else here? And I think I mentioned this. Barshali exactly here. Adam Smith was all about freedom of capitalism, and U.S. Revenue Code is crony capitalism. Exactly right. The entire purpose of the U.S. Constitution was to codify the crony capitalism. That was internal improvements, was the euphemism given back in 1791 for crony capitalism, and that's exactly what it is. Again, the predecessor or the successor was Henry Clay. Successor to Henry Clay was Abraham Lincoln, who again did impose the world's first worldwide income tax on its subjects. Very, very nasty thing that is with us to today. It's with us to today. It was really Abraham Lincoln's idea. And by the way, he didn't really have the authority to pass it, but he also he had a lot of he would arrest you if you criticized him. He intercepted the mail. He intercepted telegrams. He censored those who opposed him. Abraham Lincoln was one of the biggest monsters we've ever had, and so incredibly destructive to the idea of liberty. He was the ultimate crony capitalist, Abraham Lincoln, the terrible, terrible Abraham Lincoln. Let's see what else we got here for comments here. Right, exactly right. Wouldn't that be something? But if Canada, Australia, EU members did to the U.S. has done, the system basically comes to a screeching halt. And there, I would say, is these countries have been captured by the United States of America. That I don't believe that they necessarily represent the interests of their constituents, just like the United States government doesn't represent the interests of its subjects, right? Because if they did represent our interests, the U.S. tax code wouldn't exist. They actually cared about us. No, the whole point of the income tax is to enslave us, but not call it slavery. They don't want that. They'll call it slavery because, but that's the entire point of it, the whole deception. All right, so what else? No, by the way, I guess we should talk about what we're going to do. Concluding remarks on this, and I'll talk about what we have coming up on Friday. So, Keith, concluding remarks about this, my friend.
Oh, my God. That's all I can say. I don't know what the concluding remarks are. It's just very complicated and very frustrating and scary for Americans overseas who, for whatever reason, try or need to comply. It's daunting. So I don't know what to
Well,
say.
I would say, yeah, Keith, and daunting is. I mean, here, we're talking about an hour. We've been going over an hour on this, and really, what we're talking about is like this is what we think the law is, but the IRS Treasury won't say that we're right. That's what we've been doing, basically for an hour. Like, well, the law says this, but we have this. Why? And so, talk about a daunting tax. Absolutely. I don't know how many people trying to fill out a tax return would have the stamina to watch.
Well, that's true. And I always say, and I'll say it again, where's the incentive to comply? I mean, when you're faced with all this, I have no words.
Well, that's a great comment. That kind of leads me to our next thing is that if you are wondering if you should get into compliance, because certain times, Keith, we know it does make sense, but
you'll have to. Absolutely. I get it.
Certain times, but a great place to start is reaching out to Keith at US_overseas_advocate@outlook.com. He is not a U.S. tax professional, so he will not be saying comply, or he does not give tax advice. He gives lifestyle advice. So you can reach out.
And like I always say, what we do is we explore all the options.
There you go.
And do a risk assessment for those options so you can formulate a strategy moving forward. And sometimes that strategy is that you got to get into the system. Sometimes not. It all depends on one's profile and circumstances.
That's beautiful. Thank you, Keith, for that. John, your concluding remarks on this subject here.
This is a moral question more than anything else. Treasury did not create this problem. This comes, straight from Congress, through the very 6048 of the Internal Revenue Code. Treasury didn't create it, but boy, Treasury has an opportunity to solve this problem. Mm-hmm. And it can be solved very easily. And I hope they do. I think that it would be a step in the right direction of beginning a long process of trying to restore confidence in the U.S. tax system as it's administered towards Americans abroad. But this is a moral question, more than any other one I've ever seen.
And by the way, there is the hearing coming up on August 24th on the proposed regulations that people are asking for. John's going to be there. I'm going to try to get down there for August 24th DC. That'd be fascinating to see. We'll maybe even be able to do a live podcast from Washington with our comments after that. And now I just want to say, so I want to thank everyone for joining today. Great comments today. Really appreciate all the activity we have, and I'm learning a lot more every day. Really fascinating, brilliant commenters, and thank you so much. On Friday, we have we're going to be doing a special podcast on Friday. And Keith, remind me what we're doing on Friday. I know it's incredible.
Well, let's come up. It's like the Friday. It's going to be the streamlined program.
Yes.
Is it the panacea to solve all the problems?
Yeah.
When is it appropriate, and when is it not appropriate to enter?
Yeah, we had a little debate on Keith's group. Someone says, "Oh, streamline always makes sense." No, it doesn't. There's situations in which you don't want to do it. We're going to go over that.
Because we've never done a podcast on that.
We're going to say when you don't want to file a streamline disclosure. We're going to be covering that on Friday, July 19th at 7:30 Eastern.
And we should probably also say when you do need to file a streamline. You know what I mean? When do you do?
Yeah, I think when you should, right? And then we can certainly cover that. Yeah, exactly, when you should do one for sure. So again, if you haven't subscribed, be sure to subscribe because we do go live and we really do enjoy all the wonderful comments. I don't know if any channel has the level of intelligence that we're able to attract here on this channel. So again, I want to thank all of you for being here and spreading the word. So this is Anthony Parent for Keith Redmond and John Richardson. I want to thank you so much for joining us today, and we'll see you on Friday.